provisions in the Code of Civil Procedure we discussed. Yes, now today we'll discuss a very interesting topic, and I mentioned to you that here, under the provisions of Article 20, under the provisions of Article 20 of the Constitution of India, you cannot be compelled to criminate yourself. I mean, though accused cannot be compelled to criminate, he will not be compelled to answer certain questions which have the tendency to go against himself. That is what, dealing with the case of Nandini Satpathe's case, I gave it to you. Now, there's a departure from this general proposition that no person accused of an offense shall be compelled to be a witness against himself under the Evidence Act. Under the Evidence Act, that is Section 132 says that a witness not excused from answering on the ground of answer will criminate. He is bound and liable to answer. Similarly, under the provisions of CrPC, now what are the consequences which may flow? I will tell you. Then under the provisions of CrPC, Section 349 says that here, imprisonment for committal of person refusing to answer or produce document. So if you don't answer certain question asked by the counsel or by the court, you are liable to be prosecuted. Similarly, is the language used in Section 344 CrPC, which says that here, procedure for trial for giving false evidence. That is how it is. Because I read out to you earlier that under Section 132, you will not be permitted to excuse from answering question. Now, in the event of your question being wrong or being perjurious, at the most, the court can launch criminal prosecution against you in the nature of perjury under the Indian Penal Code for giving false evidence, but you will not be arrested immediately there and there while recording evidence under the CrPC and under the Indian Evidence Act. But a certain procedure under Section 340, please open Section 340, that is offences affecting the administration of justice. Now, during the evidence which is being recorded, it may be before a civil court or a high court or a criminal court or a sessions court or a family court or before a registrar, revenue court, in any court, if your deposition is found to be incorrect and false, if you have produced bogus documents which have the tendency to bring prosecution for others, criminate others, you can be charged for giving false evidence. Now, who can launch the prosecution for giving false evidence? Not the plaintiff or defendant, not the complainant or the accused, not the appellant or the respondent. It is the court where the evidence is being recorded. Now, please see the language of open Section 340 CrPC. Will cursorily deal with some of the 8 to 10 sections, and I will tell you how it is done, which is the court. Now, the court for the purpose of recording evidence, you will find under Section 195 CrPC. Section 340 CrPC should be read in conjunction with Section 195 in order to correctly appreciate the true meaning of this one. Now, 195 CrPC, please open it up to recapitulate your memory, because already we have dealt with it while dealing with Section 197, prosecution of judges, prosecution of magistrates. And I told you that here, the sanction of the Lok Ayukta is required to be taken for prosecution of judges. Now, in case of prosecution of the complainant for giving false evidence, who can be the complainant? That will be clear to you from Section 195. See that? Prosecution for contempt of lawful authority, 195 CrPC. Prosecution for contempt of lawful authority of public servant, those are offences under Section 172, 188. In case during Corona time you are not wearing a mask, you are committing breaches of the Pandemic Act, the police officer taking cognizance. So you cannot prosecute the officer that he assaulted me, he abused me on your own. Your complaint should be lodged by following the procedure under 195. That is the procedure laid down. Now, similarly, for for offences against public justice, offences relating to documents given in evidence, 195 no court shall take cognizance. Please see that cognizance of any offence punishable under 172. 172 is clause A, that is offences against the lawful authority, public servant, where you are giving, refusing to answer question. And B is dealing with a proposition where a person is giving false evidence under 193 to 196 of the Indian Penal Code, where the offence is allegedly committed in the proceeding in any court of law. Maybe while giving evidence in the Bombay High Court in the original site, or maybe while giving evidence before the civil judge senior division, junior division, or a district judge small causes court, or a family court, or registrar. If your evidence is against the provisions of the CrPC in Evidence Act, it's a perjury, then complaint would be lodged against you by whom? Just see that here. That section you will find it here, subclause 3 of B there. Of any criminal code, then see subsection 3 check karo clause 3 ke andar. Then of any criminal conspiracy commit the offence or abatement of any offence, except on a complaint in writing. Have you got it? Except on a complaint in writing of that court or of such officer of a court as the court may authorize in writing in this behalf, or some other court to which the court is subordinate. So that means the competency to file a complaint is by the court and not the individual litigant. Litigant will not file it here. Then what are the courts? The courts are described in subclause 3 of section 195. See that? In clause B, subsection 1, the term court means civil, revenue, criminal. It includes tribunal constituted under the central provinces, state declared by the act to be for the purpose. So it may be a DRT. DRT is a tribunal. It may be a motor accident tribunal. It may be a custom tribunal. It may be CGAT. It may be any tribunal under the law or any court of law. For the purpose of section 195, they are competent to take cognizance, file a complaint in that regard. Now, please come to section 340. Now, when the proceedings, when evidence is sought to be given, now 340 says, procedure in cases mentioned in 195. 195 means 195 of the CrPC. When upon an application made to it on behalf of or otherwise any court of the opinion that it is expedient in the interest of justice, inquiry should be made to any offences relating to clause B of subsection 1 of section 195, which appears to have been committed in relation to proceeding in that court. So 195 of the CrPC speaks of where the offences have taken place in that court while recording evidence, as the case may be, in respect of a document produced or given in evidence in a proceeding in a court of law. Court may, after such preliminary inquiry, it thinks necessary. So what is mandatory here? The learned judges, before who they file before filing of a complaint, must hold a preliminary inquiry. Whether the evidence which has been given is a deliberately false evidence, the evidence is given with a view to convict the man other side, this has been given with a view to cause prejudice to the other side. The parameters of section 193, when you see the provisions of Indian Penal Code, the relevant provisions I'll point out to you for giving false evidence, that is section the relevant section of 191, that is chapter 11 ke andar hai, false evidence and offences against public justice. 191 deals with giving of false evidence, 192 fabrication of false evidence, 193, punishment of the false evidence. 194 is very crucial, giving false evidence with intent to procure conviction of a capital sentence. A very serious offences. If this is done, the court will make inquiry. What is the object behind this man giving this false evidence? He wanted to trap somebody and put him behind the bars for maybe 10 years, 7 years, lifelong. Hold an inquiry. Number one, record the finding to defect. So, the civil court or a criminal court before whom evidence is being recorded, where it feels that the evidence is a perjury within the meaning of Chapter 11 of the Indian Penal Code, Section 191 से लेकर Section 191 to the relevant sections are 200 and I'll tell you. The last section here in this chapter is 245 of the Indian Penal Code. Then that they will record a finding to that effect after inquiry. Number two, make a complaint thereof in writing. So the normally under the CrPC complaint can be oral or will be in writing. But here for initiating proceedings, for giving false evidence, for affecting the administration of justice, the complaint must be in writing. Please note that. Whereas in the CrPC, you lend the definition of a complaint, which says that a complaint means any allegation made orally or in writing to a magistrate with a view to taking action under this code. Some person or unknown person has committed the offense but does not include a police report. So it means here definite under the provisions of Section 340. It must be in writing, it must be against a definite person. Whereas generally under Section 2C, complaint mean it can be an oral complaint, it can be a written complaint, it can be maybe against a known person, unknown person you do not know. Let the police investigate and discover him. That is the provision is more elastic here to be construed in a liberal manner, so that the ultimate aim is to achieve justice in the matter here. Then number C, 340C कहता है, send it to magistrate of the first class having jurisdiction. So the civil court or a criminal court or a revenue court with a view to taking which seizes of the matter, which is recording evidence, if it finds that here the evidence which has been given by the witness is a perjury, is offenses amounting to giving false evidence, is amounting to giving a false evidence with a view to convict somebody else in the matter from the judge, then the complaint will be sent to the magistrate first class, and so this is a procedure under 190 will be followed. On a police report, even under Section 190 A, B, C, we read it here, how cognizance is taken. So normally a complaint is framed, inquiry is held, the complaint is transferred, being tried, because there must be competency in a court to try, because a civil court cannot award conviction in the matter with regard to particular offences. But there are certain offences where the civil court can take the accused person in custody, which I will deal with it. So after recording a finding, complaint is sent. Then that order passed under 340 is appealable order. Please note that here an appeal would lie under Section 341, and the superior court may notice it here and direct because of course this is a substantive provision affecting your legal rights. In such an event, the right to file appeal is granted. Then 343 deals with 342 is cost, not important. 343 deals with procedure of the magistrate taking cognizance. A magistrate to whom complaint is made may be a civil judge, Bombay High Court, original site, while recording evidence in a civil matter between the parties, where the witness has given false evidence, sending the complaint to the Killa Court, which is in the city of Bombay, a competent magistrate to take cognizance. Now, what is the nature of complaint? See, a magistrate to whom complaint is made under 340 or 341 shall notwithstanding contain in chapter 15 proceed as far as may be, deal with the case as it were instituted on a police complaint. That means it's a police complaint under section 173. That means it becomes a warrant triable case, isn't it? We learned under the provisions of section 225 onwards what is a session triable case, what is a warrant triable case. So you learned under the provisions of, for example, section 238, that is chapter number 19, trial of warrant cases by magistrate, otherwise on a police report, otherwise that. So this will be a trial under section 238 to section 243. Please note that here, where the magistrate has the right to summon witnesses, frame charges in the matter, and proceed and convict the person. Then the procedure, how it should, after treating as a summon trial, after being as a warrant trial, but the procedure followed is summary procedure for trial for giving false evidence. It's a very unique thing here. Though the warrant trial under the CrPC is after framing charges. But in the summary trial, the magistrate is not called upon to frame any charges. He tries in a summary manner. Punishment is not granted by more than 3 months. You know that, yeah? By virtue of section 262 and 262 CrPC, the magistrate who tries this summon trial, he will not award sentence more than 3 months. So here, for offences affecting the administration of justice, when a summon trial takes place under 344, the judge for giving false evidence will not give more than 3 months time here. This is specifically mentioned here, extend 3 months time. See here, this is, I will not be reading the entire 344. See, if at all the time of delivery of judgment and fine imposing judicial proposing the court of session, magistrate of the first class expressing an opinion to that effect, the witness appearing on such proceeding had knowingly, unknowingly given false evidence or had fabricated false evidence with the intention that such evidence should be used in the such proceeding, or it may be satisfied necessary that expedient in the interest of justice that the witness should be tried summarily for giving, fabricating, as the case may be, false evidence, taking cognizance of the offense may after giving the offender reasonable opportunity of showing cause why he should not be punished for the offense. Such offender summarily sentenced to imprisonment for a term which may extend to 3 months time or which may extend to 500 rupees. Normally, under the provisions of the Indian Penal Code, for giving false evidence, punishment is a minimum 3 years. That is, when you see 196 chapter of the Indian Penal Code, I will point out to you how much sentence is given. Yeah, section 193 checker यहाँ पे 190 punishment for giving false evidence shall be so and so for a term which may extend to 7 years term. 7 years term, but the provisions of section 340 mandates that for giving false evidence, the procedure must be summary procedure. Maybe summary procedure, it is the option of the magistrate. If he does so, he cannot award more than 3 months because section 344, you please read, open section 362, 262 of the CrPC. Procedure for summary trial, the trial under this chapter, the procedure specified, trial for summon case shall be followed, except hereinafter mentioned. Para number 2, no sentence of imprisonment of a term exceeding 3 months shall be passed in the case of a conviction under this chapter. Please mind in mind. The magistrate, while trying a matter summarily in summary trial in chapter number 21, he doesn't have power to award sentence more than 3 months. That is why section 344 CrPC is in conformity with section 262. Why? Because the person, though he is under the provisions of 193 of the Indian Penal Code, if he is tried in a general manner, he will be convicted for 7 years. But if a matter is arising from a civil court or giving false evidence in a court of law, a 3 month sentence is awarded here in this matter, a lighter punishment. Then please come to know that here, they should follow the procedure summarily. Number 2 आ गया. Number 3, 340 procedure. I won't be dealing with it. 345 is important. So in 345, where a witness or any person appearing before a civil court, criminal court is indulging in contemptuous act. When a contempt takes place, or when he is browbeating the magistrate or a judge, that is an offense under section 228 of the Indian Penal Code. मैं पढ़ चुका था आपको section 228. When you open it up, you will open it. You will just recapitulate your memory. I will read it here. Just briefly. Section 20, intentional insult or interruption to public servant sitting in judicial proceeding. So यहाँ पे punishment दिया गया है generally 6 months imprisonment 228 के अंदर. Then section 175, 178, 179, 180, they deal with the proposition where the witness is refusing to give evidence, where the witness is refusing to sign papers to public servant. Maybe Hawaldar will ask you, you are driving a car without a license. Please sign this document that you are doing. You sign it, you do not want to do that. Or the police officer will call you as a pancha for recording the statement under section 100 CrPC, and you will not sign this statement. Then you are committing an offense under the provisions of section 180, or you are refusing to give statement to the court or to the police officer. Or witness summons have been issued against you. You do not appear before the court of law, or you have been directed to produce document by the police officer or a judge or a magistrate under section 175. When you commit the omission, you are liable to punishment. That is all taken as a contemptuous act under section 345 CrPC. Immediately the concerned judge has a right to detain. Detain the person. See, detention दिया गया. When any such offences is described under 175, 180, 179, 180, 288 of the Indian Penal Code are committed in the presence of the Civil Criminal Revenue Court. Even a registrar के पास भी करेंगे तो आप. Even a registrar is been held to be a court for the purpose of prosecution for contempt. When you open section 347, I'll come to know that here. Suppose you go to the sub registrar for registering your property. You are going to the registrar for determination of the value of your property or your stamp duty. You have been told to give evidence. You refuse to give evidence. You have been told to get document. No, you abuse him. You will tell him, okay, why are you asking the document? You are not a court. Why should I produce? Insulting manner. It's an abuse. He has the right to detain you for a day rising from the time till the court rising of the time. Please note that here. Then he may also ask you to pay punishment, the fine up to 200 rupees. And if you do not pay the fine forthwith, and you can be put in prison for about 1 month maximum. 344 की language देख लीजिए आप ये. These are the offences affecting the administration of justice, because you are bound and liable to respect the judges, civil judges, criminal court judges, registrar, whoever it is, all administrative tribunals. You cannot browbeat them. No, that is why demeanor of the witnesses and the person appearing before them is very important. Even of lawyers cannot also browbeat judges like this here. Then see section 346 here. Cases considered should not dealt with under 345. Now, when I told you that registrar is a court, 347 check कर लीजिए आप. When registrar, sub-registrar may be deemed to be civil court. When the state government so direct, registrar or sub-registrar appointed under Registration Act shall be deemed to be a civil court within the meaning of 345-40. That means a registrar who is registering a document under section 17 of the Registration Act, it is mandated to register certain document. आपने registration नहीं किया. It is a criminal prosecution, and you have been told to produce certain document. Your original document नहीं लिया आपने, and you have been using insulting tone, abusing the registrar. He has a right to take you in custody immediately under 345. He is a court for the purpose of a civil court for the purpose of exercising contempt jurisdiction. Please note that here, people should not get away that after all, nothing happens in a civil court or registrar. They do not have any power authority. They have been given wide powers under the CrPC, under the general law. Please note that. Then 348 speaks of when you tender an apology, I'm sorry for whatever happened, they may discharge you on the ground, because the courts are lenient in that regard if you apologize and if you are regretful of the incident. 349 speaks of imprisonment for committal of person refusing to answer a produced document. So when a document you have been directed to produce, so I told you under section 17 of the Registration Act, registrar can direct you to produce document for registration, the old records. You have not done it. While recording evidence, the civil judge will tell you under section 162 of the Indian Evidence Act, bring certain documents. Notice was given to you to produce. You are not given. Now, under the provisions of the even Code of Civil Procedure, you know that Order 12, Rule 8 CPC, a notice is given for production of document. Aapne produce nahi kiya. Then under the provisions of Order 13, Rule 1, you are required to produce original document for recording evidence. Like section 62 of the Indian Evidence Act mandate that the original, the primary document must come before the court of law. Section 64 tells you that the parties are in the first instance required to produce the original document. That is the primary. And you refuse to produce it despite the court asking you to do that. Others had given you notice under section 66 or 162, and you are refusing to produce and you are trying to probe it, and you can be taken in prison for a period of 7 days under section 349. Please note that here. I won't be reading the entire section here. Of course, for this is an important section, let us read it out. See, imprisonment for committal of a person refusing to answer produced document. If any witness or a person called to produce document or thing before the criminal court refusing to answer thing or put to him or produce any document or thing in his possession or power which the court require him to produce and does not after reasonable opportunity has been given to him to do so or reasonable excuse for such, court may for reason to be recorded in writing sentence him to simple imprisonment by warrant under the hands of the presiding magistrate or a judge committing to the custody for a term not exceeding 7 days unless in the meanwhile such person consent to be examined and answer to produce document or a thing in that event. Okay, this is why. Now this section is in total contrast to the provisions of section 132 of the Evidence Act. Just open section 132. 132 tells you, though you have no right to excuse from giving evidence that the question will incriminate you, but you cannot be arrested. But perjury case can be lodged against you. See that here? Witness not to excuse from answering on the ground that answer will criminate. See 132 Evidence Act. A witness shall not be excused from answering any question as to any matter relevant to matter in issue, in any suit or in any civil or criminal proceeding upon the ground that the answer in such question will criminate or may tend directly, indirectly criminate such witness, or that it will expose or tend directly, indirectly expose such witness to penalty, forfeiture of any kind. So 132 mandates, you are bound to answer the question. This is totally contrast to Article 20 subclause 3, where you cannot be compelled to give answer question. Because under Article 20 subclause 3, you are answering questions of investigation officer. That is not a trial. That may be an inquiry, that is an investigation. But whereas under 132 Evidence Act, you are deposing as a witness. As a witness, you are bound and liable to answer all questions. You cannot take the shelter of incrimination. Protection under Article 20 subclause 3. At the most, what the court can do you. Please see the proviso. Provided that no such answer which a witness shall be compelled to give shall subject him to any arrest. He cannot be arrested under this section or prosecution to be proved against him in criminal proceeding except a prosecution for giving false evidence by such answer. So there can be a prosecution under 193 of the Indian Penal Code for giving false evidence, but you can't be arrested. But section 349, that is a stage where a person pursuant to complaint under section 195 and 340, he is being tried before a magistrate or a civil judge or a criminal judge, revenue judge, subsequent proceeding where he makes a refusing to answer question or refusing to produce document, he can be convicted. He can be taken to jail for 7 days. So this is totally in contravention to the provisions of section 132 of the Evidence Act. So that Evidence Act provision are relating to trial. That is in the civil procedure, under the Code of Civil Procedure, after framing of charges, then the witnesses go into the box, examination, chief cross-examination take place, the list of documents are tendered, and the judge passing an order under 135, 136 with regard to admissibility, relevancy of document and question. And in the Criminal Procedure Code, CrPC, after the charge sheet is filed under 173 and charge sheet is furnished to the accused person under section 207, then charges are framed under section 2011. After charges are framed, the prosecution commences the proceeding under in a trial before a court of session, or in a trial before a court of session in warrant cases, or a trial before the magistrate in summons cases, whatever may be. So during the trial, if the accused person or a witness makes false statement, his statement, he can be held for perjury, but he can't be arrested under 131. And he is bound and liable to answer all questions which are relevant to the subject matter in issue before the court of law. He cannot say, I will not answer this question, this will take me into custody. No. But 140, 349 will come into play when the civil judge or a magistrate or a revenue judge has taken cognizance of the matter that this man is deliberately giving false evidence. He has produced a bogus affidavit with a view to carry conviction, to seek a wrong declaration, to grab the property of XYZ, or produce a bogus will of his father with a view to deprive the share of his brothers and sisters. If the court is prima facie of the opinion that this is primarily perjury under sections 193 of the Evidence Act, the court will file a complaint under 195 CrPC, that is offences affecting the administration of justice, where a second trial takes place. In the second trial under the CrPC, under 349, if he repeats this mistake of refusing to answer question and producing bogus document, he will not be spared this time. He will be taken in custody for a period of 7 days. Please note that here. That is 349 is totally different from the provisions of section 132, and 132 of the Evidence Act is different from Article 23 of the Constitution of India. This you must bear in mind, this distinction. Now please come to 350. Summary procedure for punishment for non-attendance by a witness in obedience of a summons. So when a witness, because this provision is also covered under the Indian Penal Code, when I dealt with you the provisions of Indian Penal Code, that is a contempt of lawful authority in public servant, that is section 170, absconding, avoiding to take summons, warrant को execute नहीं करने दे रहे हैं and not signing the papers. 175, omission to produce document, omission to notice. 175, furnishing false evidence. This is all provisions dealing from section 170. Section 172 से लेकर 172 से लेकर the 190 of the Indian Penal Code. See that here, summary procedure for punishment for non-attendant. So here, if you do not produce document which have been summoned, which you don't appear before the court of law as a witness, you cannot say that here nothing will happen. So the court can issue warrant against you and put you behind the bar for a period, punishment not exceeding. There's a punishment of 100 rupees fine. There's also punishment here as may be practical procedure prescribed. So the same procedure, you can be taken in custody by the magistrate following the procedure under 344, 345, where you can go to the jail up to 7 days. That procedure is followed. Please see section 351 में same procedure. Then lastly, that when such orders are passed, they become appealable under section 351. Suppose if the order is passed by the city civil court or taken action against you under 195 read with 340 CrPC, though the magistrate has tried and put you behind the bars for a period of 7 days. So you can file an appeal, like see, 351 said that any person sentenced by any court other than High Court under 344, 49, 50 may notwithstanding anything contained in CrPC can appeal to the court to which the decree or order may be made. So under the Code of Civil Procedure, it's an appealable decree under section 96. Padhe na aapne? When a final order is passed, it's an appealable order. Just open section 96 of the Code of Civil Procedure. वो 96 खोल लीजिए. Appeal from original decrees. देखिए that appeal from the original decrees mean, suppose for example city civil court has passed an order for you, final order asking you to vacate the premises. It's a final decree. Appeal would lie to the High Court under 96. A district court has passed an order. The appeal will come to the Bombay High Court. Civil judge, junior division, senior division passed the order. Appeal would lie to the district court. A court of small causes court has passed a decree. An appeal would lie to the division bench of the small causes court. So this is under 96 may. Similarly, when a conviction is recorded by the magistrate under the provisions of 344, 345, 349, if it's a conviction recorded by the judge who has taken you in custody, city civil court judge, you will come to High Court under 96. If it is taken by if you have been convicted by the small causes court, an appeal would lie to the Court of Small Causes Court under section 35 of the Maharashtra Rent Control Act. Then it's a family court, you will come to High Court under 96 because the appellate decrees are a High Court. And if it's a cooperative court, appeal would lie to the cooperative appellate court. The appellate court is there. So that's the original court. Because the criminal court should not be burdened, there is no need for you to appeal the sentences in the Court of Session or the High Court in its appellate jurisdiction. The powers are given. That means the contempt was taken against you. You gave false evidence in the City Civil Court, Bombay High Court, Small Causes Court, or a district court, civil judge, junior division, senior division, or before a tribunal. So though your complaint was tried following a procedure under 195 and 340, though you have been convicted by the magistrate and taken in custody, appeal powers are relegated back to your original court. Namely, if it is arising from High Court, you will go back to High Court. Arising from City Civil Court, again, wherever the appeal lies under 96, District Court or Small Causes Court or a tribunal having appellate powers. See how interesting this is. Very, of course, it's a confusing, but a young lawyer, he is very enterprising, is quite interesting. It is the law is made. You are made to go from pillar to post, from one court to other court. You should know that. And if you go and knock the doors of a wrong court, the object must be here with a view not to overburden the criminal courts by under the appeal. So go back to the same parent court which has taken cognizance and referred the complaint, and they can try the appeal because the entire record is with them. That is the object behind. Then say 352 says, certain judges and magistrates not to try certain offences when committing before themselves. 344, 349 के अंदर other than the High Court magistrate person censor under 195. So यहाँ पे there is a bar contained here that the power with regard to trying is given to the Bombay High Court and the other courts where the offence is committed, and not to all magistrates, but in the city of Bombay the cases are referred to the Chief Metropolitan Magistrate. In villages and the district area, they are referred to the Judicial Magistrate, the Chief Judicial Magistrate. Please note that. That is the bar content. So anybody want to ask me any question in today's topic, please ask me. This is the end of all evidence and offences affecting the administration of justice and punishment and penalty for tendering, giving wrong evidence, false evidence, and tendering document which are forged document. किसी को कुछ पूछना है पूछ लीजिए आप before we jump to other topic. The time permits. Yes, there is a time for about 20 minutes. We can deal with it. Anybody has any question? Please go ahead. पूछना है पूछ लीजिए जल्दी से because we will not be wasting time. So after recording evidence, इसके बाद क्या procedure होएगा? देखिए उसके बाद there will be arguments before the court. If nobody has questions, I will further take up the topic. See that oral arguments. He open kari section 314. After recording evidence when both the parties have closed evidence. So to recapitulate once again here, after the trial, in the CrPC evidence commences under the provisions of section 272 onwards. Inquiry. Yeah, but in apne, isn't it? I won't repeat again. Following the provisions of the Indian Evidence Act and the relevant provisions of the provisions of the CrPC, you should know that here that is a inquiry trial and evidence in trial case. That is a section 272 se lekar, please remember 300 tak, very important. After then Evidence Act may, I won't again repeat, one the examination chief, cross examination and leading question वो सब सीख गए आपने, CPC के अंदर भी सीख चुके हैं. Then offences affecting them. So after the evidence is closed, then after the accused person has been told to lead evidence. So you know that accused statements are recorded under the provisions of 311, isn't it? I won't again repeat it. If circumstances are going against, before recording evidence, the magistrate or a judge will ask the explain to the accused person, please explain the circumstances which are gone against you. 311 procedure is very important. 311 ke baad, accused is told to examine his witness under 315. He has the liberty. After the closure of the evidence of the parties, there will be oral arguments. Argument between by the parties and by the lawyers. Parties mean here lawyers. Lawyers of both the sides will commence argument. That provision I just pointed out to you. The provisions of section 300 and yeah. Yeah. 314. Okay, आ जाइए. Oral arguments and memorandum of arguments. Order 18 के अंदर CPC में आएगा. I'll take it up here. Now see, any party to proceeding may, as soon as may, after the close of his evidence and address, concise or oral arguments may from before he conclude the oral argument, if any, submit a memorandum to the court setting forth concisely and under the district head the argument in support of his case, and every such memorandum shall form part of the record. So you can give a written argument which is called a memorandum, which will be used under section 80 of the Evidence Act. Will be read. Then copy of the memorandum to be simultaneously furnished to the other party. If the public prosecutor is arguing and filing it, he has to give it to the accused, defense counsel, and defense counsel leading evidence and giving oral argument, he has to give it to the prosecution. Then the court may, in the opinion, extend the time. So remember this, 314 is important. ये argument होने के बाद, please note that what will happen, the matter will be set down for judgment. Please see the judgment is chapter number 27, starting from section 353. So I am completing the entire trial court procedure. Judgment देख लीजिए. Then tomorrow we'll go through the cursorily appeal revision proceeding, which I have already taken earlier. But to recapitulate your memory, how in a sequence of order I will take you. Today I will just give you how the judgment take place under section 353 onwards. See, you all read and come. I don't be reading and wasting time. This is what here, how the learned judge should record judgment. He must deliver judgment. Then 353b, reading the entire provisions of IPC to be quoted, and he must give a copy. Please read it here. 353 pad lijiye aap. That is the next step in the matter, and he must furnish a free copy to both the parties. The matter, that is the mandate. Okay, that is a section 353 ke andar. What is the language is given? 354. The language of the court in Maharashtra, it can be Marathi also, English also. Since the judgments are likely to go to the appellate court to Supreme Court, translation is mandatory in the matter. Then 355 specifically deals with the Metropolitan Magistrate judgment. Because in the trial court, how the trial court record judgment, he must give serial number, date of the commission of the offense, name of the complainant, name of the accused person, and he must give the nature of the offense complained, brief narration of the fact. Then the plea of the accused he must record. Plea, that is a framing of a charges if necessary. In a warrant trial, charges are framed, isn't it? In a warrant. But whereas in summon trial, warrants are not. Then he must record the plea, whether the accused has accepted the case or not. Whether that is called plea. Guna kabul kiya nahi kiya. That is a plea recorded. Then final order passing, then date of the order. That is very important. In cases an appeal lies from the order under 373, a brief statement of the reason for decision. Because the learned judges, metropolitan magistrates are bound and liable to record reasonings in the judgment, because the appellate court should know, the sessions court or the high court, superior court, whether the judgment is supported by the facts of the case, by relevant provisions of law, judgment of the Supreme Court or High Court, on what basis again. Then 356 deal with notifying address of previously convicted offences. Then when that is in cases where the accused person was previously convicted under 215, 489 A, B, C, that is counterfeit coins cases ke andar, what kind of a judgment the magistrate has to give. Okay, that is the narration of fact. Then more important is section 357, 357A with regard to order of compensation. The magistrate, while passing an order, he may say that the complaint is false, frivolous, prosecution is totally not proved the case beyond reasonable doubt, and he may award compensation. Or he may even award compensation to the victims. That is the compensation where the court imposes sentence of fine or sentence in this matter. Read this section 357 very clearly and come. We can discuss question answer session next time. 357, 357A bhi pad lijiye aap. That is a 357 a victims compensation scheme. How the rape victim, how the victim who has been harassed due to frivolous litigation, he should be awarded compensation by the court. 357A, 357B, 357C, ये जरा पढ़ के आ जाइए आप. I will take it as a question answer session on the next date. 358 भी पढ़ लीजिए. What is the extent to which the magistrate can award sentences and as well as the compensation is given in that regard. Okay. Then while awarding cause judgment के बाद, the court, after convicting a person, if he finds that the accused is a first-time offender, and his credentials are very good, he's come from a good family background, and he's a student or a employed person coming from a good family background, he may release him on probation and good conduct after giving admonition. Dhamki dega, usko dhamki dega, bond do, and don't repeat these offences again. Offences punishable up to 7 years, he has the right to grant him probation. That is section 360 or Probation of Offenders Act. I will deal with it along with this section here. 360 pad lijiye, where the person can be released on probation. I mean, though he is convicted, it is not a acquittal. He is convicted, but on account of good behavior, coming from a good family background, having regard to his age, having regard to the nature of the crime, and having regard to his social condition, the court may grant him a probation and he may let him off. Then 360 1, 2, 3 deal with cases where the copies must be given to him free of charge. Court not to alter. I told you 362 के अंदर the criminal courts do not have review powers. They cannot alter judgment. Please accept typographical mistake. Whereas under the Code of Civil Procedure, under 47, Order 47, Rule 1 CPC, all the civil courts have power of review under Order 47 as well as Section 114. But that privilege is denied to the criminal court judges. Unfortunately, neither the magistrate nor the session court judge nor the high court has any review powers, except for high court has power under section 482 inherent power, can pass any orders. Barring high court, other criminal courts do not have inherent powers. Similarly, they do not have power to review the judgment, unlike the civil court judges here. That is 363. I have read out to you, giving illustrations of many judgments earlier in that regard. Please go to that. वो देख लीजिए. Then उसके बाद confirmation of sentence when a person, when has been convicted by the court of session, he is convicted to kind of life imprisonment or is convicted to hanging. That is a 366, 367, 368. You require the sanction of the High Court for awarding death penalty in that regard. That I will discuss with you. Okay, please read and come 366 to 371. Under the provisions of law, death sentence can only be confirmed which is passed by the court of session. Death penalty subject to the confirmation by the High Court. That is section 366. High Court has a power to hold inquiry. High Court has power to set aside the submission. Under 368, High Court may sentence it or may annul the conviction. Wide power are given to the High Court in this matter. Confirmation are done under section 369 CrPC. Confirmation or new sentence. High Court may say that we are not convicting this man. He has been, session court say that the offense committed by him is a serious crime, rarest of rare case, falling within the ambit of the Supreme Court judgment, and he should be awarded death penalty. Death penalty, hanging till his death. But the High Court can set aside the same. Evidence and record doesn't support the case here. So 369 can be invoked here in the matter. That procedure, read and come, 369, 371. 366 से लेकर 371. Very simple procedure here. Okay. This much portion will wind up today. And appeals का लूंगा मैं. Anybody want to ask me any question right now, you ask me. Otherwise, tomorrow, next lecture, you ask me before we proceed. We'll deal with it. Okay, anybody has any one question? I think we already covered 1 hour's lecture. Anybody wants anything further, I can continue. Or I think it's a festival season. I do not want to detain you. Okay, you can enjoy your festival. But anybody has any question, please ask me. Till that, so far we dealt with the portion. कुछ पूछना है आपको पूछ लीजिए. Tomorrow we'll meet and take the other portion. Is it Kumar? Tomorrow okay? We are meeting. Is it okay?
Yes, sir. Totally.
Okay. So I will take my lecture same tomorrow 7 to 8. 7 even Friday I will take. I will be here. So anybody has any questions? कुछ पूछना है तो पूछ लीजिए. Tomorrow I will also deal with the Code of Civil Procedure में how the evidence is wound up and how the arguments commence and what are the provision for judgment and why the judge passes it. दोनों cover कर लेंगे. You come to know. You can synchronize both of them and study accordingly as per yourself. Okay. No questions. I take it then. कुछ क्वेश्चंस हैं कुमार, सुजाता, मलिका, गर्गी, कोई है क्वेश्चन?
No, sir.
नहीं. Okay, then all the best. All of you have a excellent evening. Enjoy your festival season. Okay, tomorrow we'll meet up tomorrow same time 7 to 8. Okay, good night.
Okay, sir. Thank you, sir.
Okay, good night, dear.
Thank you, sir.
Bye bye. Good night.